Welcome to everybody, distinguished professors, colleagues, and participants. On behalf of the Roman Bar Association President, Avvocato Antonino Galletti, I want to give you a very warm welcome in this meeting. As usual, I prepare a little speech, but in this case, I will speak with my amazing English, with words that come from the heart, directly. First of all, I want to be very grateful to everybody that contribute to this meeting and to the project. I want also feel a great pleasure to give the thanks to the public entity that contributes at the project INTERLEX, and now I will say their name. The first of all is the Alma Mater Studiorum from Italy, the Apis Europe from Bulgaria, il Consiglio dell'Ordine degli Avvocati di Roma, obviously from Rome, Italy, the Mazarykova University from Czech Republic, and also the European University Institute from Italy, Università degli Studi di Torino from Turin, Italy, and Università Constance. All these public entity and enterprise gave the contribute to this European project co-founded, and so is very important this meeting, because is one of the final meeting of all the project. Is the occasion to understand the results and the goals that the project reached. So it's better to don't lose time and go immediately to see what this project reaches. I stop my speaking and I give directly the word. I hand over to my colleague Cristina Tamburro. She is also a member of the Council of Roman Bar Association, and she will expose all the fundamental results and matter of the INTERLEX project. Please, Cristina.
Thank you, Alessandro, and welcome to all participants. The Bar Association of Rome is really proud to be part of this project. And I just would like to spend a few words about the INTERLEX project, with its EU-funded project, started in September 2018, with the aim to develop a platform for providing information, decision support, and training on private international law. As we know, over the last 2 decades, the European Union has deployed significant efforts towards the harmonization of private international law, based on the competence stated in Article 81 of the Treaty on the Functioning of the European Union. And in particular, the European Private International Law provisions aims at harmonizing the following issues. Which state court has jurisdiction in private matters having cross-border implications, which state law is applicable in such matters, and under which conditions can a foreign decision be recognized and enforced in another member state. The matters covered includes internet law, of course, in particular contracts, torts, intellectual property, data protection, etc. And in this context, it is fundamental to understand which are the interaction between European and national law on private international law, commonalities, differences between different private international law instruments, and at the national and at international level. And also the global dimension of today's information society generates many new complex legal issues pertaining to internet-related private international law. The development of computational models of private international law can enable a deeper understanding of the logic of private international law instruments, of overlaps, inconsistencies, and gaps, and can support both the application of private international law regulation and their reform. That's why the INTERLEX platform is intended to use such technologies to identify which legal system have jurisdiction in a particular case, the law of which state is applicable, and retrieve relevant legal materials. And so in this context, INTERLEX project aim to give support of, first of all, the upskilling of legal professionals, improving knowledge of legislation and case law in the domain of internet-related private international law, where the cross-border judicial cooperation is required. Help ensure that the legal frameworks and the regulation linked to judicial cooperation are in line with the EU legislation and relevant case law of the Court of Justice of the European Union, increase awareness of judges, legal practitioners, as lawyers of course, and policymakers of judicial cooperation issues, increase legal awareness of economic operator in the digital economy, and help them identify potential legal issues and access relevant materials, provide free service mainly directly to legal professional and law students, but also accessible to all EU citizens. With this transnational training, we would like to increase the awareness over the activities of the INTERLEX project. We hope you will enjoy this and the following sessions. I would like just to thank you all for your attention and thank you for your participation. And now I give the word to the other participants. Thank you.
Thank you, Christine.
So, please, Federica Casarosa, could you start your presentation?
Yes, this we have switched with the Francesco in order to be sure not to overburden from my voice and my presence from today and tomorrow. First of all, I would like to introduce myself. I'm Federica Casarosa. I'm part-time professor from the Center for Judicial Cooperation, and which is one of the partners of the LEX project. I'm really proud to be here, and I really thank Alessandro, Cristina, and Andrea Pontecorvo for the work done in a short time with very compelling deadlines, because unfortunately we are looking forward to the end of this project, which is the 31st of January, and we will have prepare and organize these national training events under the pandemic conditions. So we have to reorganize one of the most relevant deliverables of the project according to this limitation. I would like to follow up on what Christina was mentioning earlier regarding what is the INTERLEX project. And I will speak on behalf of Luigi Di Caro, who is the project leader from the University of Torino, and Giovanni Or, who is the other participant that is in charge of the technical and informatics. I may say that given that I'm the under the legal perspective, I really appreciate to have the expert on the other side that has explained me how to have tackled the most difficult part of translating legal rules into something that is more structured and reliable than our interpretation is. So if I am correct, I will try to show and share my screen. Just a second. Here we are. No. I tried. Yeah. Let's try if I can you if you can see me. I would like to present the INTERLEX Transnational Training Workshop, and I will a couple of minutes before the presentation by Mr. Di Napoli regarding what is the background of our project. As Christina was mentioning, the EU legislative instrument of private international law provide for uniform governing the conflict of international law situation. But we have to address the problem of a set of intricate and overlapping rules that are applicable under different circumstances. And it is a matter for judges and lawyers to understand matters of private international law that is very, very complex and very, very difficult. So even experienced lawyers find difficulties in addressing these issues. So the issue was that we have a dispersion of EU law. We have an overlap between national and rules, because you are perfectly aware that current EU rules are regulations. So we do not have any implementation issues, but they may have competence between EU and rules. So we may have a situation where the EU rules can be applicable, but national ones be possible to have the in the spots or areas where EU law rules do not apply. We have a multi-level system, and there is a development of EU jurisprudence that have address different cases and different problems with the specific cases that have to be addressed within the lens of national rules. So we have a level of complexity, and we have a lack of systemic approach. So at the end of the day, we as a project team, we developed, or at least we select an area where these rules can be most relevant for lawyers and judges. That are the internet-related cases where the private international law has a transnational dimension, because obviously we will have a situation where the contractual relationship or tort cases have to have a situation where national rules may conflict and apply on a different levels. So the as such can transcend national barrier and may involve different legal systems. So in these cases, it's even it's not possible to avoid to apply or take into account international law. So the idea was to have a platform where these issues and these cases can be addressed easily and a help to the national lawyers and judges in overcome these complexities. So the idea was developed through a project, a 2-year project, as mentioned by Cristina, that has been funded through the European Justice Program. And the lead of the was the University of Luigi Di Caro, as mentioned. We have a set of partners that are across Europe and include Europe, University of Bologna, the University Institute, the Masaryk University, and the Council of Bar Association, that is our host for today, and the University of Constance. So the main deliverable projects are for your use and hopefully in order to make sure that you have banding and improve your knowledge on private international rules related to internet cases are the national reports that will be available and are addressing countries that are covered by the project, so they will be available on the website of the project. The comparative report, that is of the different instances that emerge at national level, and will be presented by Esther in the following presentation. And then, which will be the most relevant and most useful deliverable from our project, is the INTERLEX platform that will be presented in detail tomorrow afternoon, and hopefully will help you to address not only the national rules that are applicable to the cases, but also to provide a set of tools to address the that you are doing, and help you in identifying the courts that are competent and the law applicable, without having to identify, or at least to spend time in identifying such norms and such rules. This is for from my short presentation, and I will just get back to and I'm very pleased to leave you the floor and present and allow you to present one of the important cases of the European Court of Justice on private international. Esther, the floor is yours. Please feel free to use the time allocated to you. One very housekeeping matter. We are in a situation where we have 3 rooms, and the difficulty is to exchange views and with the parents from Rome and from abroad. So in that case, if any of you would like to have questions and doubts or suggestions for the discussion, please feel free to add them to your chat rooms within your rooms, and we will try to make sure to have them collected, presented to the speakers in due time.
Sorry, Federica, from the technical room. Federica, can you hear me? Federica, can you hear me?
Yes. Yeah.
Okay, we are experiencing some problems with your audio. your system is quite slow and the internet connection is not in a good shape right now. So if you can turn off all the other applications on your computer.
I only have
Already done? Already done?
Yeah, I only had, yes.
Okay, and please speak loudly, clear and loudly, more.
Yes.
Nearest the computer, the nearest it is, the better it will be. Okay, thank you, and sorry for this interruption.
Sorry for these technical problems. I hope that you have the opportunity to listen to me and to the presentation. But I'm happy that now the floor will be to Esther, and you will be enjoying her presentation better than mine.
Thank you very much, Federica, and thanks to all of you for your presence. Particularly thanks to the COA of Rome for hosting this meeting today, to Antonino Galletti, to Alessandro Graziani, Cristina Tamburro, and to my partners in crime, in INTERLEX crime, during the INTERLEX project I had the chance to work with. I'm Esther Di Napoli, I'm an attorney at law, and I teach European Private International Law at the University LUMSA of Rome. During the INTERLEX project, I had the chance to work on the project with the University of Torino. And I'm very glad to see that today's meeting, which is actually the last meeting of the INTERLEX project, actually mirrors the interest that legal operators have in private international law, not just European private international law, but also with the interaction between private international law and, in this case, the internet, which is one of the fields where European private international law, together with European private international law, is actually dialoguing, and it's something that needs to be looked at. And as Federica and Cristina have already stressed, it's important that these new issues, internet-related private international law issues, need to be addressed in order to make things clearer, as there are no ad hoc that we will see in private international level, and so it's important that interventions like the INTERLEX portal and these projects have been carried out. Well, in this very limited time together, I will give you a very short overlook of the European Union perspective of the questions that have been addressed with the project. That is the European private international law perspective, which actually also helped us in giving a kind of uniform tracks also to the national reports that have been prepared by the partners and the collaborators in the project. Because from the European report, as we will see, we tried to find common guidelines applied in national member states. So trying to see whether what has been decided at the supranational level has been actually reflected at the national level by national courts. As it has already been addressed by Cristina and Federica, the European Union in the last decades has been developing a quite important, a well-advanced corpus of rules in the field of judicial cooperation in civil and commercial matters, which is actually the European expression to refer to European private international law, according to the language of the European legislator. And as we have already seen, the rules adopted by the European Union in this field are pertain basically to three groups: rules on jurisdiction, rules aimed at identifying the competent court, the jurisdiction aimed at deciding over a cross-border case. Conflict of laws rules, that are rules aimed at identifying the substantial applicable law applicable to the case, and rules on recognition and enforcement, that are rules aimed at defining the conditions for the recognition and enforcement of decisions rendered in different member states and then recognized and enforced in other member states other than the ones which issued actually the decision. The nature and the shape of the rules on private international rules, on these rules on private international law, have significantly changed over time. In fact, before 1999, before the Treaty of Amsterdam, thanks to which first the European Community and then the European Union was granted competences to adopt measures on judicial cooperation in civil matters, uniform rules on private international law were the outcome of the negotiation between member states, that is, international conventions, according to Article 220 of the Treaty of the European Community. And as we well know, the outcome of these, let's say, all the private international law are basically the 1968 Brussels Convention and the 1980 Rome Convention, the first devoted to set forth uniform rules on jurisdiction and recognition enforcement in civil and commercial matters, and the second one, the Rome Convention, aimed at identifying uniform conflict of laws rules in the field of contractual obligations. Today, as we've seen, the legal basis for these rules on private international law are Article 67 and 81 on the Treaty on the Functioning of the European Union. And as a result of the appointment of these competences to the European Union, and in the context of the progressive communitarization of private international law, these two conventions, main private international law conventions, have been substituted by regulations. Mainly, as we've seen, as Federica has stated, there are mainly regulations on private international law. And these two conventions have been substituted by Brussels I regulation, then substituted by Brussels I bis regulation, and then the Rome Convention was substituted by the Rome I regulation. However, despite the European Union has been undergoing an exponential but sectorial development in the field of judicial cooperation in civil matters, the scholars mainly have considered that the time is not yet ripe to justify the creation of a genuine system of European private international law. This means that at the European Union, we won't find any general part of private international law as it happens at the national level, as we will see from the national reports that will be presented in the next session. So scholars have been stating that it's no time for a Rome Zero regulation. And this discussion has actually been left in 2010. The European Parliament touched upon this discussion. Scholars also at the Italian level also addressed this issue, but we might say that there's no general part at the European level on private international law. The European private international law has been progressively eroding national private international law systems, leaving then national private international law instruments a residual function. The measures then adopted under Article 81 of the treaty are mainly regulations. I've already said that, which means that they are binding and directly applicable in all member states. In addition to this fruitful activity of the European legislator, the quasi-legislative activity of the Court of Justice of the European Union has considerably contributed in developing the European private international law framework. Also at the time of the previous conventions, Brussels and Rome conventions, thanks to a protocol that allowed their interpretation, even if those instruments were just conventions and not properly European instruments. The increasing role of the European private international law has also had a great impact in the development of the European single market and in general on the ongoing process of European integration. For the time being, the total amount of regulations existing in the field of judicial cooperation amounts as around 19. There are 19 regulations currently applicable in the field of European private international law, counting also the field of family law, which was not touched upon by the INTERLEX project, counting, but of course not taking into consideration the 3 last regulations that will be applicable running from 2022 in the field then of family law, which is Brussels Ter regulation, and the last regulations that have been adopted in the field of service abroad and taking of evidence abroad. Well, let's say the framework, the current framework of judicial cooperation in civil matters and old regulations currently applicable in this field can be easily seen and consulted at the European e-justice portal, which is a portal constantly updated by the European Commission and easily found online. Well, since the advent of the internet, the new media and communication technologies also, since from the advent of internet, also the communication technologies have also been developing. And this development, this evolution of the internet and corresponding technologies has led to 2 main consequences. On the one side, the number of online social relationships and commercial transactions have increased. And on the other side, at the same time, the number of online cross-border disputes has also increased. And this has deeply affected the implementation of European private international law rules, in particular the rules on jurisdiction and the conflict of laws rules applicable to contractual and non-contractual obligations. In fact, the European private international law instruments adopted so far in the field of judicial cooperation in civil matters, which of course were not conceived to be applied to encompass situations related to the internet. Imagine that the first Brussels Convention was adopted in 1968 and the transposition to regulation was made in 2001. So let's say the development of European private international law has really gone together with the development of the internet. So these European private international law rules need then to be shaped or better readapted to the current situation and therefore in the light of the digital environment. In fact, on the one side, the European private international law rules, which are designed to be applied to offline situations featuring one or more international elements, are geographically oriented, as it means they rely on the principle of territoriality. think about, for example, the connecting factors of domicile, habitual residence, but also of the element of the criterion of the locus commissi delicti, for example. These are all elements that are linked to a territory, to a geographic, they have a geographic nature. And on the other side, internet has progressively carried out a process of dematerialization of legal relationships. In fact, internet gives rise to an intangible and evanescent space, the non-space, a non-space, the cyberspace, which is intrinsically borderless and independent from any geographically location. In fact, it is commonly accepted that any activity performed within the digital environment has a ubiquitous nature. I like to recall the fact that the word cyberspace comes from a merge, a fusion of two words, space, which recalls actually the territoriality principle, but also from, it's also made of another word that comes from Greek, which is cyber, which means rudder. In Italian is timone. And this means that legal operators, let's say, to surf on the internet, also from the perspective of European private international law, relating to internet-related situations, we need kind of coordinations in order to surf properly and to have coordination to surf and be able to move within the sea of the digital environment of the internet. The virtual and global dimension of online disputes actually challenges the traditional legal categories of private international law and calls for new legal solutions, or at least for an appropriate adaptation of the existing rules that are devised for similar situations, but not properly shaped on the internet, on the situation, on the internet environment. The fact that still persists a lack of uniform private international law approach on the matter, on these internet related private international law situations, actually it determines a substantial gap in the internet governance. And this legal scenario actually leads to conflicts of jurisdiction, and ultimately to legal uncertainty and instances of forum shopping. What I will briefly mention in the time that actually still remains is a small window to the case law that was adopted by the Court of Justice of the European Union, and actually trying to give you and us, the legal operators applying European private international law, some coordinations to deal with situations involving internet and cross-border implications. In fact, the Court of Justice of the European Union rendered actually several decisions concerning the interpretation of European private international law instruments in relation to the digital environment. And these, I actually, during the period of the INTERLEX project, we selected a number of 27 judgments relating to the issue concerning internet-related cases from the perspective of European private international law. And the fields that we witnessed were basically concerned, consumer protection, so contractual and non-contractual obligations, and in the field of contractual obligations, consumer protection, and in the field mainly of non-contractual obligations, torts, delict and quasi-delict, and mainly data protection, copyright, and last but not least, defamation. So let's say defamation online. What I would like to stress here is that the Court of Justice of the European Union, dealing with the cases related to the internet and private international law, readjusted the principles that stated and created in situations and previous case law, even ancient, let's say, case law, dealing with offline situations which had nothing to do with the internet. For example, in the contract, in the field of contractual obligations, the case that was developed, the principles that were developed in the case, the Color Drac case, which was a case of 2005 dealt with by the Court of Justice, which entailed the identification of the competent jurisdiction, the competent court, in case of multiple deliveries. Well, in that case, the principle that emerged in that case, that was the principal place of delivery, then that principle was then transposed to other situations that actually entailed internet-related situations. For example, in the Peter Reder case, that was a case that was decided was a case of 2008, decided a couple of years later. The Court of Justice had to decide which court was competent in a contract with an air company and undersigned by an air passenger with an air company, in case the ticket was purchased online. In that case, the court established that unlike deliveries of goods to different locations, the contract, that kind of contract purchased online of an air ticket, was to be considered a contract for the provision of services according to Article 5, Paragraph 1, Letter B, second indent of then Brussels 1 regulation, today Brussels 1 bis regulation, Article 7, 1b, second indent. And in that case, the court pointed out that, I was saying, unlike deliveries of goods to different locations, which are distinct and quantifiable operations for the purpose of determining the principal delivery on the basis of economic criteria, in this case, air transport consists by its very nature of services provided in an indivisible and identical manner. So it's not possible to find out whether there is a principal place of delivery, like in the Color Drac case. And subsequently, is interesting that the court better developed the idea, the case of the so-called click wrapping contracts, that are actually contracts that are purchased online, like air tickets, like in the case of the Peter Reder judgment, and subsequently in a case of 2014, Jouad El Majoub and Kaz versus Kaz on the web. In that case, the court that in that case the click wrapping method actually constitutes a communication by electronic means, which is capable of providing a durable record of the agreement. In that case, and also what happens mainly with, for example, with the Ryanair contracts, air tickets purchased online, the air passenger actually agrees on a court, on a forum there, and actually there is a choice of court agreement. So the court has been progressively clarifying that the method of the click wrapping, that is double clicking on the website of the Ryanair or other air companies, actually constitutes a method that, according to Brussels 1 regulation, in particular Article 23, but Article 25 of the Brussels 1 bis regulation, which is capable of constituting a communication by electronic means that actually allows a durable record of the agreement, and that actually the agreement is valid under also formally valid. What is interesting in the field of consumer protection, still on the in the field of contractual obligations, is that the court has been giving legal operators a kind of non-exhaustive list of matters, of situations that can help legal operators in identifying constituting the evidence from which it may be concluded that actually the situation entails a consumer protection, a consumer contract, when the contract with the consumer is concluded online. And in the Peter Palmer case, which is a case registered in 2009, it was reunited. It was a reunited case. There were two cases, joint cases of 2008 and 2009. In that situation, the court provided a list of matters from which it may be concluded actually that that the trader's activity is directed to the member state of the consumer's domicile, which is actually an element that helps in identifying the contract, the consumer contract. And among these elements in the list, there is that the international trade nature of the activity, the mention of itineraries from other member states going to the place where the trader is established, the use of the language or a currency other than the language or currencies generally used in the member state where the trader is established. And among other things, but I will just finish here, the mention of a telephone number, which and with an international code, which actually helps identifying this activity towards the consumer by the business part. As I don't have much time left, I will just skip to the end. By of course, I am of course available to any questions that might arise. By saying that, and of course, the report on the European report is available online. So I'm saying nothing new actually. And what I would like to conclude is that the Court of Justice approach to the interpretation and expression of the expressions used in European measures adopted under Article 81 has progressively been changed by the Internet. The Internet has very much influenced the approach of the Court of Justice. And in its prolific quasi-legislative activity, which means that at the European level, as I said, there are no ad hoc measures entailing internet-related private international law issues. However, the quasi-legislative activity of the court has been helping the work of both the legislator, but mainly of legal operators applying such measures to situations entailing the use of internet. So far, this adaptation of traditional European private international law rules conceived to operate offline is now left, as was been mentioned before my presentation, is now left to a case-by-case approach. And this approach, while ensuring flexibility, on the other side actually may jeopardize predictability. And this is why the Iure Condento, some scholars have asked for a change in the European legislator measures, actually having approaching directly with ad hoc rules, dispositions, the issue concerning internet-related situations. However, this has not been done yet, so all the issues surrounding the matter are left to a case-by-case approach, to a case law approach. And therefore, the Court of Justice of the European Union's case law actually declined in the digital environment actually invites a reflection on the tightnesses of such measures. The activity of the Court of Justice, as there's nothing currently left at the normative legislative level, the Court of Justice activity becomes even more relevant on this in this situation. And as its interpretative function relies on an in-depth understanding of private international law, it follows the need and we are all witnessing this together today. It follows the need for experts to explore European private international law dimension of the digital environment and to underpin the work of the Court of Justice of the European Union. And among recent and positive experiences, among them, of course, our INTERLEX portal. There are experiences of associations like the EAPIL, the European Association of Private International Law, that actually helps the development of this situation, of this matter. Thank you very much.
Thank you very much, Esther. You have a very detailed analysis of what has happened under in the Court of Justice jurisprudence, and I really appreciate the points related to the fact that the courts, first of all, have tried to adapt to the principles and the rules that were originally not drafted for the internet sphere towards the new technologies. So that are no more new because we are obviously working with them from latest decade. But still they are new for the law because we have still, and in some national reports that will be presented later, there is some reluctance from addressing this approach and taking the rules as they stood and as they were developed for technological means. So it's very interesting that this is an effort that has been tackled by courts and by interpreters, not by the legislator. And this is a very important burden on the activity of lawyers that will be obviously present their views and their interpretation to the judges, but also to the judges that then will be following or addressing these issues in terms of application. So this is really relevant. And this is also related to the point that you were mentioning regarding the trade-off between flexibility and predictability. Because one thing is that the fact that we may have interpretation and adaptability to different situations, but this may have an impact, a very strong impact on how the decision will be taken and will have a different outcome depending on which interpretation is taken. So this is really an important effort, and I'm sure that events like this will help the practitioners to realize that it's not always the fact that we are alone in terms of how to interpret, but also the cases that has been presented to the Court of Justice is a matter of national courts' doubts and triggers. So it is for the national courts, for the national lawyers to present these issues and to present these doubts and problems, and then there will be, so in this collective effort to solve the problems that emerge. So this is not just a matter of seeing the Court of Justice as an actor that devotes its time to address cases that are coming from nowhere, but it's really a dialogue, an interaction between courts and lawyers at national level with the European Court. So sorry for my intervention, but I really appreciate your presentation. And again, if any question or doubts or suggestion comes from the audience, from the lawyers from Rome that are participating in person, and lucky you that you are enjoying this event in person, or in an online context, please feel free. We will try as much as possible to gather your suggestions and questions and make sure that you are answered by Esther and by the other speakers. But without losing any more time, I would like to pass now to the panel discussion. And as mentioned before, we have the opportunity to have national reports that are coming from different countries and different contexts in order to ensure an analysis of how national courts have addressed private international law instruments in internet-related cases. So we will have this panel discussion with three national rapporteurs, and we will have Mateusz Groszowski, which is Senior Research Fellow at the Max Planck Institute for Comparative and International Private Law in Hamburg, but is our national expert on Polish jurisprudence. And then we will have Sara Migliorini, that although the name clearly identifies her as an Italian scholar, she's an expert on French jurisprudence and is working as a research fellow at the British Institute of International and Comparative Law. And then we will have again Esther as with a new hat in this panel as the national rapporteur for the Italian jurisprudence. I will ask all the panel participants to contribute to the discussion with a presentation that can last between 15 and 20 minutes at most. So feel free to start. I will just give the floor to Mateusz, and we will follow the list as in the program. And if you want to share your screen and your presentation. One point, I have been confirmed by the technical expert that we will be able to share with you the presentation, the slides, and the content that has been created for this event on a dedicated page. It will be provided to you because there will be Andrea Pontecorvo that have confirm this availability. So don't worry, we will also disseminate all the content and all the presentation that we have presented to you today. Mateusz, please, the floor is yours.
Thank you, Federica. Thank you, first of all, for the invitation to this event, and also for your invite to the INTERLEX project, because like this whole endeavor of going through the case law of Polish courts and trying to track down sometimes very non-obvious and sometimes very vague references to private international law issues in the internet context that were made by Polish courts was a kind of a very instructive and very, I think, challenging sometimes task. And in my short presentation, I will try to summarize briefly the main findings of the Polish part of the project, and I will also try to provide you with some more overarching conclusions on how Polish courts approach the conflict of laws issues in internet-related cases, how the EU private international law is or is not employed in this kind of disputes, and what may be the possible reasons behind it. I will try to share with you my screen right now. I hope it will work. Can you see it? I hope it works. Okay, so my presentation was prepared together with my colleague from Krakow, with Katarzyna, who was also co-responsible for the Polish part of the research, and who was assisting me with both doing the case law study and with putting together the final report. So the conclusions I'm going to present are in some part our mutual joint outcome. And first of all, while doing a comprehensive search for the internet-related cases which involve the private international law element in the Polish case law, we came across 22 cases altogether. And these are the cases decided by both civil, criminal, and administrative courts, so by all branches of the judiciary. And as you can see, the vast majority of these cases were the cases decided by both the courts of the first and of the second instance. So very few of these cases were ending only at the first instance level. Most of them were later on double-checked, let's say, by the courts of appeal. And in a significantly high number, so in about 45% of these cases, the third instance, so the Supreme Court or the Supreme Administrative Court, were involved also in checking whether the application of law in the case was proper, which is also quite interesting from the perspective of the possible precedential potential of these cases, because in many of the situations, the final decision in the case was issued at the level of the Supreme Court or Supreme Administrative Court, which means that it was able to set forth a particular standard for understanding certain problems of private international law in internet-related disputes. So, and indeed, many of the cases I'm going to talk about in detail in a second were the cases where the Supreme Court or the Supreme Administrative Court said something quite substantial about application of EU private international law in internet context, and somehow contributed to development of this branch of private law. In the, let's say, about the half of the cases we came across in our study were the cases concerning the personality rights. So the cases were various forms of online defamation, online like spreading some information which one of the parties considered to be false or untrue or harmful was concerned. And these are both the cases where various forms of like direct internet communication was at stake. So where certain information was spread through social media like Facebook or Twitter, or where some internet fora were at stake. But also a substantial number of cases within this 50% you can see in the diagram, were the cases where the defendant in the case was a media actor, let's say, in general. So these were mostly some foreign newspapers which were presenting some information both in the print version and on the website. And this website channel of spreading information was targeted as the principal area of defamation, of infringing some personality rights. The other types of cases, as you can see on this graph, were contractual disputes, were including also some consumer cases, which sums up to around about 27% of the whole sample of cases. In a small fraction, and these were mostly cases decided by the administrative courts, these were cases related to online gambling, and also to copyright issues where the copyright infringement, the alleged copyright infringement was committed online. Here you can see a very brief summary of the subject matters of the cases that we were trying to investigate. And in the let's say left column, so the contractual obligations, most of the cases were concerning contracts, various types of contracts, including contracts for shipment of goods and certain goods in the transborder relations. Some of these cases were subjected to the general private international law rules, including the general EU law provisions on the conflict of laws, whereas some of them, especially the contracts on the carriage of goods, were also governed by some international treaties, like, for example, the CMR Convention on the Carriage of Goods. In consumer disputes, we had some like typical consumer cases where, for example, which involve, for example, consumer sales or the unfair contract terms issues, and we also had a group of cases where the unfair commercial practices regulation was involved. In the non-contractual obligations, apart from the personality rights I have mentioned, were various kinds of defamation, various kinds of fake news was considered. We had also various cases related to the right to be forgotten, where the case law of the European Court of Justice was applied by the Polish courts, and also certain cases where various kinds of unlawful conduct, including, for example, illegal online gambling, including domain piracy, and so far was involved. However, what is particularly interesting, I think, from the perspective of the INTERLEX project and from the vantage point of the EU private international law, is a brief glance on how the Polish courts were, in fact, applying various, let's say, levels of the private international law regulation, and how they were where they were looking for the solution to the problems they came across in the cases. And as you can see in, let's say, a significant fraction of the collection of cases we identified in the project, courts applied both the private international law rules and the EU case law. So they were not only referring to both the domestic and the EU substantive law, but they were also trying to look for some interpretive patterns in what the European Court of Justice has said already about particular rules. Secondly, in a very small number of cases, courts were referring only to the EU case law. And it was, for example, these were mostly the cases concerning direct to be forgotten, where the Google Spain judgment of the European Court of Justice was a kind of a highlight for the Polish courts. In some cases, courts applied only substantive law without engaging themselves in any kind of judicial dialogue with the European Court of Justice. And last but not least, in a very significant number of cases, and at the end of my presentation, I would like to return briefly to this phenomenon. Polish courts were quite negligent in applying any kind of private international law related reasoning in the case. So on the one hand, they were not applying any kind of either substantive law-based reasoning or any case law-based reasoning. And at the same time, in many cases where it was quite evident that, for example, a particular tort was committed online, or that a contract was concluded online, and, for example, there may be a problem of territoriality or the problem of the various places of residence of the contracting parties, courts were quite oblivious to this fact and were not trying to draw any legal consequences from the fact that a particular contract or particular tort happened in this transborder online environment. So the whole conflict of laws dimension, the whole private international law related character of the case was set aside by the courts and was not mentioned, or was mentioned very briefly only in the motives of the judicial decision. And now I would like to give you a few examples of the cases which we found particularly interesting or particularly noteworthy from the perspective of the INTERLEX project. And first of them is a judgment of the Supreme Court of 2014, which considered the Euro football championship, which was organized jointly by Poland and Ukraine in 2015, and where the problem that the Supreme Court tackled upon was the question whether the contract, which was drafted by UEFA, which concluded the choice of law clause for consumers, was acceptable or unacceptable under the 9313 directive, so under the test of unfairness of clauses in consumer contracts. And this particular choice of law clause was designed for the purpose of subjecting all of the disputes between the UEFA and individual consumers who, for example, purchase tickets for the football games to the Swiss law, so to the law of the place of residence of the venue of headquarters of UEFA. And it's particularly important from the perspective of the online contracts, because this clause was directly applicable to the transactions concluded between UEFA and individual consumers who, for example, were purchasing tickets, were purchasing some additional services connected to this Euro Championship, to football games from UEFA, and who are concluding all of these contracts online using some UEFA websites or some associated websites set in Poland and Ukraine for the purpose of this Euro Championship. And the Supreme Court found that this kind of clauses should be considered unfair because it can be misleading to consumers. It can create some de facto obstacles for consumers to claim their rights before Swiss courts, even if from the substantive point of view, the level of the standard of protection awarded to consumers is the same or is very similar under the Polish law or under the, let's say, the law of any other EU country and the Swiss law. So regardless of this substantive equality party of rights, this kind of clauses under the Polish Supreme Court judgment should be considered unfair. However, in another judgment of the Supreme Court of 2017, it was ascertained that in the situation of the defamation dispute, of the personality rights related dispute, where this alleged tort was committed on Facebook, in the context of the competition law dispute, so where two professional parties are involved, and one of them claims that the other one did something harmful to the good reputation, to the possible level of trust of customers by publishing something on Facebook, on social media, then, according to the Polish Supreme Court, it should be ascertained that the tort is committed in a place where the harm to competition caused by the online material actually occurred, and then we should, following this finding, we should apply corresponding rules on the non-contractual obligations, so the Rome II regulation of the EU, plus some possible domestic rules on the conflict of laws. What is particularly important for this judgment is that in this kind of very particular context where we have the online defamation plus the unfair competition deed, it should be ascertained in which country of the EU let's say the harm to the economic interest of one of the competitors actually took place. And thirdly, another interesting defamation dispute, and again a judgment of the Polish Supreme Court of 2019, where we had the director of the Polish school in Ireland, who again posted on Facebook and in some other places, in some other source of information online, the defamatory claim about the possible fraud of the school budget. And in the situation where we had and both parties involved in this situation, so both the person who posted this information online and the person against whom this information, this defamation was directed, were Polish citizens. And at the same time, one of these people was also the plaintiff in this case was also running for the Polish Parliament at that time. But at the same time, both parties had their habitual residence in Ireland. And in this situation, in this particular conundrum of the citizenship and the place of residence, the Supreme Court found that to establish the jurisdiction of Polish courts, it's necessary to establish that the tort inflicted interests in the Polish territory. Which, of course, in this particular context, when we think about the parties who reside in the foreign country, but at the same time, at least one of them has a direct connection with the Polish territory because he is running for a political position in the country, in the public election, then it directs our thinking towards this kind of interest, which not necessarily has to be an economic interest, but which may nevertheless link this person with the territory of the other country than this person actually resides in. And also, what is important for this last defamation case is the fact that this Facebook content, and let's say in general the content which was available online, could be reached by readers also from Poland. So from the country where, as I said, is say direct link between the plaintiff and the territory was able to be, well, could be established. Okay, and now just a few words of summary. So first of all, as I said, in a significant part of the cases we were investigating, the courts did not pay enough, or paid only very little, or paid almost no attention to the fact that the case actually involved any sort of transborder, transnational element, and especially they were not paying enough attention to the fact that the case was in fact concerning some online IT-related issue. For example, courts were in many cases were not interested, for example, in establishing how particular information was transferred, who could possibly reach the information when it was published online, comparing to the situation when this information would be published only in the paper media, and so on. Secondly, courts were focusing mostly on, let's say, physical residence of the party, especially of the plaintiff, sometimes also of the defendant, and was not interested in establishing, for example, how the information was circulating, and, for example, where the information was stored, who was responsible for example, running particular internet forum where this information was spread, and so on. And thirdly, internet and all of the internet-based communication media, like Facebook, for example, were considered only to be like typical ways, typical channels of spreading information, like a telephone or like a paper mail, but were not considered to establish a self-standing particular domain where particular torts can be committed. So it also seemed to us that sometimes Polish courts were missing this peculiarity, specificity of internet as a platform for social interactions. And lastly, it was quite vivid for us that in comparing between business to consumer and business to business disputes, courts were paying more attention to in-depth analysis of cases concerning consumer interests, as opposed to business cases. So in the disputes between professionals, courts were rather reluctant to go in-depthly into the question of how the presence of internet communication could, for example, influence parties' interests, how it can change the result of the private international law scrutiny of the case, so the result of establishing which law should be applicable in the case, and so far. And secondly, it seems that courts were also not always very proficient in distinguishing between various levels of the EU legal order. So they were not very proficient in resolving conflicts between the EU private international law and domestic rules. And for example, in some cases concerning the right to be forgotten, some courts were applying EU law and were referring to EU case law in the first place, and some courts were trying to refer to the domestic rules and look for the possible solutions on the solely domestic ground, putting aside the EU context of the case. And thirdly, in a very scarce number of cases, courts were making meaningful use of the case law of the European Court of Justice, although in a significant number of examples they were making references to the ECJ decisions in a substantially negligible number of cases. This reference was being made to achieve particular substantive results. So sometimes it was like, at least we had this impression, it was purely decorative. It was a reference without any direct meaningful consequences for the case. Okay, so this is all I wanted to share regarding the highlights, the most important parts of our findings from the study. Thank you again for your attention, and I will be open to your questions. Thank you.
Thank you, Mateusz, and thank you for the thorough presentation of the. Yes, you're right. We can clap, but we can cheer for the presentation, but unfortunately, we will not have the opportunity to make you listen from our, but I will try to provide you my thanks for the presentation, for the very detailed analysis of how Polish courts have addressed this type of issues. It's interesting that you're mentioning this distinction and this different approach, or at least different level of attention between B2C cases, so business-to-consumer cases, vis-a-vis business-to-business cases. So I suppose that this is also related to the fact that the courts rely on the expertise and on the capability of businesses to address their relationship and to address the ways in which the overlapping jurisdiction may have addressed within their contracts. Whereas in cases of consumers, we may probably see that courts are aware of the limited knowledge and the limited expertise of consumers vis-a-vis this type of problems, and the fact that they may be unable to grasp the technicalities of private international law. So I suppose that this can be one of the issues where this approach, one of the reasons why this approach is emerging. But obviously there can be also other reasons, and every other. Yes, please tell me if this is.
Yes, I think that may be one of the reasons. I agree. I think the other reason may be that I think it has been changing over time, but Polish judges are becoming more and more aware that whenever they have a consumer dispute, and whenever they have a consumer in a case, there is this whole background of the EU law which has to be taken into account. So basically, whenever there is a consumer-related dispute, I think it just flashes a light in the heads of many judges that they should look more thoroughly into the ECJ case law, into the directives, into the regulations, and so far and so on. And I think in B2B cases, and also in the cases concerning, for example, defamation, where the portfolio constituted like a hub of what we managed to find in the Polish case law. Courts not always, I think, tend to see these cases through the lens of the EU law. They are not very much aware of the fact that, for example, there may be some conflict of laws which is at stake. They are not always, I think, which perhaps maybe also can be also explained by not like imperfect way of educating judges about private international law in Poland. But I think they are not always aware that when they have a dispute concerning, for example, a Polish citizen in a German newspaper, a very typical kind of dispute in this cluster, they should look into, for example, EU law and into the wrongful regulation on the for example. So yeah, so I think Federica, there is a whole bunch of possible explanations, and I don't know which of them is correct to speculate.
Okay. No, thanks a lot. But this is something to think of in order to select and to understand why this is the case and why the courts may have more attention to one type of cases and to vis-a-vis another. Well, sorry for this discussion, but I think that it is interesting to see what is happening across the board and to learn from different experience and to identify which are the most problematic issues at national level. Now I will give you the floor to Sara Migliorini, that is currently connected from Hong Kong, so I'm sure that she will be having a very strange situation, speaking about France and being settled in a different country. So I hope that you will have the opportunity to provide some highlights of the regarding the French report and the French jurisprudence. The floor is yours.
Thank you, Federica. It's true. I'm an Italian speaking about France while from Hong Kong, and I work for the British Institute of International Comparative Law. So I'm a cross-border situation of my own. And it's almost midnight here, so please bear with me if at some point my thoughts are not as clear as they would be kind of 6 hours ago. But I will try to make it quick and also to the point. I was also kind of noting what Esther said before, and also Mateusz, because I think there are some links and some ideas that we can also connect to what I saw happened in France with respect to our topic. So, but first of all, let me also say that I'm very grateful for participating in the INTERLEX project. And it really gave me the opportunity to uncover some very interesting stories and looking at how French courts approach European private international law in general, and also how they approach the issue that has been mentioned before of adapting rules that are not thought to apply on the internet for internet-related cases, but actually have to be at some point. So let's start from the beginning. Private international law in France, I think, is a rather known discipline. Courts and practitioners in general are trained in private international law. And as a general remark, I would say that courts always take into account the rules of private international law and apply them. Of course, we witness mistakes or inaccuracies in the application of those rules, but generally speaking, French courts are quite reliable, and that also, of course, is relevant in our topic for internet-related cases. There are various reasons why this happens, and so this is interesting to compare what happened in Poland. I will use the word negligence because the national reporter from Poland used it. But so this kind of very, I would say, scholarly approach of French courts to private international law has different reasons. One of this is the role of the Supreme Court. The Cour de Cassation has issued guidance in the form also of reports and notes. So it guides lower courts in the application of private international law. There are also historical reasons. Some courts in France have been adjudicating cross-border cases for a long time. Paris, for example, and Versailles, near Paris, where many companies, foreign companies, are based. So there are these two poles of expertise about private international law and arbitration that kind of are the core of case law. They have adjudicated a lot of cases in anyway, and so there has been capacity building in private international law in those courts, and it kind of spelled off in the other codes. But even if private international law is known and applied, that doesn't mean that sometimes there are national approaches that may square uneasily with private international law. And one that I always like to mention is the fact that, well, European private international law is predicated on the assumption that you can always tell whether something, a legal relationship, is either a contract, or if it's not a contract, it's a tort. In France, that is not the case, and not so many jurisdictions know this, but have the same kind of figures that cannot really be categorized as tort or contracts. And of course, this has been a problem in the application of the rules of the Brussels I and Rome I regulation, but also Rome II. But anyway, this has not prevented then a scholarly debate, and most of these issues are now solved at least at national level, even though we don't have European case law on all of them, of course. Another issue that is quite strange to me when I look at the French legal order as, a French qualified lawyer, but someone who has also done a lot of comparative law, is that in France, private international law rules are traditionally considered optional. So parties, lawyers, have the possibility to agree to just kind of set aside any private international law rule and just litigate on the basis of French law most of the times. But of course, I think this shouldn't be possible when the rules of private international law are have the nature of European regulation. They shouldn't be optional. It can be optional. But I don't think there has been a very thorough debate on this, and the issue is not settled as of today. So, but for what concern us, besides these very specific problems that may arise, I would say, generally speaking, private international law is applied and known. So in my report regarding internet-related cases, I discussed 17 decisions, 13 of which came from the Supreme Court, the Cour de Cassation, 1 from one court of appeal, and 3 from a court of first instance. So in the area of contract, I will discuss the 3 cases from the Court of First Instance, which is actually the Court of First Instance of Paris. And these cases are really interesting stories. And again, I think we have a really interesting comparison with what we just listened about Poland. So these 3 cases have been adjudicated between the summer of 2018 and the summer of 2019, and the appeals are pending. So these are public interest litigation. This is part of public interest litigation brought about by consumer associations that since a few years have locus standi in front of the courts to represent the interests of all consumers in specific issues. Not all consumers associations can, but there are a few that meet certain requirements, have been certified for having the possibility to bring this kind of public interest litigation. And this association brought actions against the kind of Goliath of the internet, Facebook, Twitter, and Google. And they were alleging that something like 200 plus terms of the contract, of the terms of use of these three platforms were actually unfair under European law and, of course, under the French consumer code, because European law it was at that time on the applicable law a directive. So there was a lot of national implementation and provisions. So the argument was, for our purposes in private international law, the argument was some of the clauses of the terms of use are unfair because they are choice of court and choice of law agreements in favor of US courts and US law, the law of some US states and the court of some US places. And I think the reasoning of the Court of Paris was really interesting. And here we see one of the issues that we mentioned. Courts have really to be creative in a way and also open-minded when it comes to apply rules that are not thought to be applicable on the internet or not exclusively, and try to make them square with, you know, this territory where there's no boundary and not national kind of national border. So the courts reasoned this way. So the terms of use of Facebook, for example, is actually a contract. And it's a contract with the user that it's not gratuitous. There is an exchange. It's use of the platform against data, because then Facebook and Twitter and Google use the data that we provide to the platform for commercial use. So it's not for free. We give data, they get the data and get to use them. And we get the use of the platform as an exchange. So because it's a real contract, consumer law applies. And in particular, under French consumer law, European consumer law, choice of courts and choice of law agreements that kind of strip French users or consumers of the protection granted by French law are actually null and void. So that was the reasoning of the courts, and all the terms of use that were considered unfair were actually considered null and void. As I said, appeals are pending, but this is the law for the moment. And I think it's interesting, again, with respect with what was mentioned before, that in France, because of this particular setting of public interest litigation in defense of consumers, those associations that are authorized by law to bring those actions actually have expertise in private international law and more generally in European law and European consumer law. And they can actually bring forward creative arguments that actually benefit consumers in the end. And I think this case is really testify of this possibility, actually. Going forward to torts. This is also another interesting story about how it actually works in France and actually how important is private international law for the French legal order. So in the field of torts, there has been a decade-long disagreement internal to the court of to the Supreme Court, to the Cour de Cassation. So let me just give you some background and then get to the real point. The French Supreme Court has several chambers. So 3 of them are civil chambers, civil chamber number 1, 2, and 3, and 1 is the commercial chamber. And of course, they all have different jurisdiction on different matters, but it's not always very logical, at least to me, how the matters are divided among the chambers. So, for example, if you look at IP, some of it it's part of the French Civil 1 chamber, and some of it is part of the commercial chamber. So it's also a little bit difficult sometimes to understand why. And against this background, the first case about an internet-related adjudicated in France by the civil chamber, the first civil chamber of the Supreme Court. So, of course, there was a litigation before, but the imported judgment is the one from the Cour de Cassation in 2003, saying, well, it was a case of a trademark infringement that happened on the internet on a Spanish website, but the trademark was registered in France, and the owner was based in France. And so the question was, do French court have jurisdiction? Because in the end, everything seems to happen in France on Spain, on a Spanish website, and there's no and there's no apparent link with France. But there, the first civil chamber said, well, if you have to locate a tort, we need to find a link. And for us, the relevant link under Article 5.3 of the Brussels Convention, and of course its progeny as well, is the fact that from France, we can actually access this website. And that was it. So it was, if we look at how elaborate it is, and maybe sophisticated, much more sophisticated is the case law of the European Court of Justice on the matter. Well, this case really leaves you a little bit like that, because then, of course, we know that websites are accessible from everywhere. So we need to kind of define a little bit more what are the other relevant factors to actually anchor the jurisdiction to France. But anyway, that was it, and it was 2003. And that was the first civil chamber. So after that, for some reason, the first civil chamber didn't have to adjudicate any other internet-related tort for more than 10 years. During this time, a lot of scholars were criticizing the first approach of the civil chamber, and actually managed to convince the lower courts that that kind of idea of just looking at whether you can access a website from France and that's enough to ground the jurisdiction, well, was heavily criticized and was abandoned in favor of a very different way of thinking, that it's not enough to for a website to be accessible from France, but it actually has to target the French public. So we are really at the other end of the spectrum. We need to find a website that really targets the French public. And if we go through the case law that it's in my report, some of them look at whether you can have products delivered, order products and have product delivered in France from a website, whether there's a French language version of the website, and so on. And so the lower courts were applying this very different criteria. And the opportunity to adjudicate on a case related to a tort on the internet came across for the commercial chamber of the Supreme Court, the Cour de Cassation. So the different chambers cannot overrule each other, but the commercial chambers was really persuaded that these other criteria was right. And in the meantime, of course, we had witnessed the E-Date judgment and Wiestengaide as well. So we really knew that we had to be a little more sophisticated, that, accessibility was the basis, but then depending on the different subject matter, there has to be a little bit more of an inquiry of courts in what are the other factors that can be relevant. And but besides all that, there were not really cases that commanded the application of E-date or other cases. But so, okay, I was just checking the chat in case I was the one to whom the message was directed. The commercial chamber simply followed what the lower courts were doing, and very strictly applied the idea that only if a tort happened on a website that somehow targeted France, then French court would have jurisdiction to adjudicate on it under the Brussels regime. In no other case, it was the French jurisdiction was grounded or was justified. So this kind of very difficult to explain for someone who's not familiar with the legal system situation occurred where, the first judgment in 2003 saying, well, if the website is accessible, then jurisdiction is grounded, was good law. But also the other much more restrictive judgments of the commercial chamber were also good law. They cannot overrule each other, and there was no plenary session to kind of solve the matter. So what the two chambers did was actually very interesting. They talked among each other through two different reference for preliminary ruling that they submitted to the Court of Justice. So in 2012, the first civil chamber referred a question for preliminary ruling to the Court of Justice, and we had then the Pinckney decision. After that, it was clear that the idea of accessibility was important, with all, the other kind of restrictions or qualifications that are in that judgment. But the basic idea of accessibility was still valid. And since then, the first civil chamber followed its own idea of accessibility that was in line with what the Court of Justice was saying. But the thing is, the commercial chamber hadn't, after that, an opportunity to adjudicate on another tort until 2015, when they were the referring court for the Samsung Electronic case in a matter of unfair competition happening on the internet. And there was the end of the saga, because the Court of Justice issued the judgment where, accessibility or targeting the French public, it's not really the main issue, but we have to look at other factors, where the sales are, and what is the court that is actually protecting the right in question. And that kind of settled the matter. But it's very interesting to see that for over 10 years, without actually never being in violation of any case law of the Court of Justice, the two chambers of the same court actually had a very different idea of how to apply the criteria of jurisdiction to torts happening on the internet. And yes, this was a very interesting story to uncover. I think I could just finish here because I see it's almost 5. But of course, if there's any question, I'm here.
Thanks, Sara. For anybody who would like to address questions to our speakers, please feel free to add their questions to the chat that are using within their own rooms, and we will try to find out a way to address this question to our speakers. So feel free to add questions. I was very interested in the presentation by Sara because it's clear that we have a judicial dialogue emerging from these interaction between lower courts and Supreme Courts, and the fact that these different chambers do not achieve results, or at least a common ground until this final decision in 2015. And it's interesting that in these cases, there were never the idea to address a question to the Court of Justice, even if these cases are obviously related to a national interpretation of the law. So it is interesting to see that in order to avoid the intervention of a third actor that could have, let's say, interfere within the very delicate balance among the national courts, we do not have the possibility to address this preliminary ruling or the question towards the sorry, I have some return from my voice.
We can hear you fine.
Okay, fine, perfect. So the idea is to have a very difficult understanding of these national rules and national interpretation that may evolve throughout time. So it is interesting that it's also one of the issues addressed by the French courts was the idea that the data exchange, so the fact that data was addressed as goods that have been exchanged between platforms and users, is also an interpretation that now is used in EU law. So this is also something that was really, let's say, also forward-looking by French national courts. In this discussion,
yes, I will just say to on the issue of tort. Actually, the first civil chamber, at the first opportunity that they got, the first time that they were seized of a case that they actually referred a question for preliminary ruling. But the thing is that the commercial chamber had a few occasions before, and it didn't do it because of its competence, its jurisdiction, that, the Court of Justice had never spoke of that particular matter. So they thought, well, that's clear. I don't have to because it's clear. So they kind of found a loophole. They were never in plain violation of something that the Court of Justice has said. They kind of found a loophole and stayed there until the other chamber decided to go and seize the higher court in a way. So it was really interesting to uncover this story. Absolutely.
Yeah, thank you very much, Sara. And now I leave the floor again to Esther Di Napoli, who will provide us, in this case, the Italian perspective, the Italian jurisprudence, so the report on the Italian perspective. So please, Esther, the floor is yours.
Thank you very much again for giving me the floor, and I promise I will be very short, not just because I'm talking mostly to Italian colleagues, but we'll see that the Italian case law, the practice, is not very much developed in this field, but we will see that it is increasing, and so we are hoping that also together with this intervention of our project and other projects that are actually being carried out, I will be mentioning them briefly at the end. The practice will be increasingly increased. From a legislative point of view, differently from what happens in France, and thank you very much to Sara for her very interesting presentation, and to Mateusz as well for the Polish perspective. The private international law dimension in Italy is made basically by Law 31 of May of 1995 to number 2018, the so-called Riforma del Sistema Italiano di Diritto Internazionale Privato. There is the General National Act, the so-called Italian Private International Law Act. And this national law actually sets forth the overall the Italian system on private international law. It includes, and as all systems of national system of private international law, also a general part of private international law, what is actually lacking at the supranational perspective, at the supranational level, as I was mentioning in my first intervention. So preliminary issues, lis pendens, iura novit curia renvoi, and other general topics that are considered as the general part, on private international law. The Italian Private International Law Act has been progressively modified and ultimately eroded by European Union law, as I mentioned before, and mainly by measures adopted by the European legislator according to Article 81. The last modifications to the Italian Private International Law Act were made in 2016 following law number 76, the so-called Legge Cirinna, and the subsequent law decree of 19 January 2017, number 7, modifying and reorganizing the Italian private international law system in the field of civil partnerships. In spite of what other member states do, for example, Germany, but also Spain, the Italian legislator does not nationalize, allow me to use this term, the Italian legislator does not nationalize European regulations adopted in the field of judicial cooperation in civil matters within the internal system. Such measures as naturally, they directly apply in Italy without any national measures of not transposition, but of integrations considered to be necessary. Something that is very it's a novelty, it's a brand new measure at the Italian level, is actually the legislative decree. This is the first time that the Italian legislator integrates with an Italian measure, legislative measure, a European regulation on private international law. And actually, recently, just at the very end of last year, we adopted a legislative decree integrating Regulation 655 of 2015, establishing a European account preservation order. It's a very important mechanism that doesn't it's just the only example we have in Italy of integration through an Italian legislation of a European legal measure on private international law. As the Italian Private International Law Act was adopted before the European Union was granted competences in the field of judicial cooperation in civil matters, it still contains references to all international private international law instruments as the conventions mentioned before, the Brussels and the Rome Convention mentioned before. And according to the majority of scholars, however, these references should be considered as implicitly made to the corresponding most updated versions of transposition within the European European regulations, regulation Brussels 1 bis regulation, Rome 1 regulations, Rome 1 regulation, and so on. As far as non-contractual obligations are concerned, Law 218 does not contain any reference to European legislative instruments nor to international conventions. And with regards to torts, Article 62 provides for the application of the law of the country where the event occurred. And specific then provisions relate to non-contractual product liability set forth in Article 63. The Italian Private International Law Act does not contain any provision which specifically relate to the digital dimension. And according to the research carried out among Italian case law focused on private international law internet-related issues, the legal relationships that mostly develop throughout the digital environment concern contractual and non-contractual obligations, basically refer to contractual obligations, mostly contracts concluded online. Mainly we have a good jurisprudence on click wrapping contracts, that is contracts that I was referring before, concluded online with air companies, and with reference to non-contractual obligations to rights to personality, like as defamation, and intellectual property rights. There is actually, as far as contractual obligations are concerned, there is no evidence to relevant case law concerning the application of private international law rules with regard to consumer protection in the online context, even if we very much know that this field is fruitful, is rich of practice. So consumers actually have gone online. However, the only case which incidentally deals, that was selected and actually deals with the relevant rules of private international law, is a judgment rendered by a justice of the peace, giudice di pace of Trapani, concerning the liability towards a consumer of an airline company for international carriage by air, which, however, did not deal with private international law related issues. This lack of Italian case law on internet related private international law issues could be, in my opinion, partially explained by the fact that Italian Consumer Code provides for an alternative dispute resolution, ADR, systems which have been preventing consumers from bringing actions before courts. And as we know, ADRs have been introduced by Legislative Decree 130 of 2015. As already mentioned, apart from personality rights, the Italian Private International Law Act does not contain specific rules related to the fields of law which are likely to be involved within the internet, such as intellectual property or consumer protection. I've already said this. In conclusion, what actually arises from the research, in addition to the proper application of European and international instruments, the research actually shows that Italian courts often recall those instruments in order to solve, by way of analogy, issues that actually would fall outside of their material scope of application. This means that often Italian courts refer and apply European private international law instruments even to solve purely internal situations, which is not that correct. Actually, it's wrong. In conclusion, Italian courts, I've selected 17 judgments concerning the application of mostly European private international law rules in internet-related cases. 7 were rendered by the Supreme Court, Corte Suprema di Cassazione, 9 by lower courts, and 1 by a justice of the peace I have just mentioned. The decisions I will not focus on the detail of all these decisions. I will just refer to the national Italian report that is available online. These decisions show actually two trends. On the one side, the majority of the cases concern the direct application of European legal instruments. And in this regard, it shall be stressed that Italian courts, which directly apply European legal instruments, mainly rely on principles set forth in well-known judgments of the European Court of Justice. This means that judges, but also attorneys at law, work and defend their clients before national courts, very well know not just the legal instruments applying in the specific case, but also the case law interpreting expressions of contained in that legal instruments. On the other hand, the other trend shows how Italian courts occasionally recall European private international law to resolve, as I have already mentioned, issues that such as internal territorial competences in purely internal cases, even if the Italian jurisdiction is undisputed. This means that there is a kind of a confusion between jurisdiction and territorial competence. So sometimes courts refer to private international law to just define territorial competence, even if Italian jurisdiction is undisputed. In one case, we saw how one court, the Milan Court of Appeal, referred to Article 5, Paragraph 3 of Brussels I regulation, referred to jurisdiction on torts, in order to establish Italian jurisdiction in criminal matters. This is just something that we noticed, and of course, this is not properly made. Let's say it's not correct as well. Just a couple of insights. The Supreme Court in the field of contractual obligations rendered 4 decisions, 2 judgments and 2 orders, applying private international law in internet-related situations in the field of contractual obligations, but basically referring and interpreting, applying the rules on Brussels I regulation and 1 bis regulation referred to choice of court agreement, therefore deciding whether the conditions to set forth a valid clause on choice of court agreement were there. No case law applying European private international law in the field of consumer protection. This has already been stressed. By way of conclusion, I can say that even if the number of decisions selected does not show a big let's say, corpus of case law in the field of internet-related private international law issues. However, we could say that the number is, however, is consistent, and in particular is potentially growing. The attention towards private international law issues in the digital environment, particularly in the field of non-contractual obligations, is also significant. I did not have time to tackle this field, but this is what we saw, and the same consistency, the same relevance might be, as I already mentioned, referred to low-value controversies arising in relation with online sales contract concluded with airlines, that is point and click wrapping contracts. We have to remember that the parties, the air passengers, are not considered as at the European level as consumers as we do at the national level, but as in the Peter Rader case, the Court of Justice underlined, the passenger, is to be considered as just a party in a provision of service contract. There is also, let me just add this, that there is an added value in an added issue concerning accessibility. Transnational cases involving air companies and passengers are frequently dealt by justices of the peace, and who decide in Italy over controversies not exceeding 5,000 euros of value, and whose decisions are not available unless they're published in specialized journals. In this perspective, in this dimension, I would like to underline some projects that are helping accessibility towards this kind of case law. And among others, there is the SCAN project, the Small Claims Analysis Net project, which is a European funded project aimed at analyzing actually the European small claims procedure introduced by Regulation 861/2007, which actually is used to claim money from air passengers. In the Italian perspective, then, in order to raise awareness on these topics, which is the most important thing, and we are here witnessing this, training activities, and I'm concluding on the intersection of technological and legal developments shall be more frequently organized and addressed to legal operators, but also not just legal operators, but to private citizens and companies through events, seminars, and as well as through the establishment of networks of permanent groups or think tanks. Thank you very much.
Thank you, Esther, again for this very thorough analysis of the Italian jurisprudence. Though limited, we see that there is still some work to be done, and I hope that the events like the one organized by INTERLEX, but also the one organized by the other project that you were mentioning, the EU claims project and the others, are helpful in terms of clarifying and helping legal practitioners to address these issues, but also to enlarge the number of potential target users of this information. I would like, first of all, to thank all the panel participants. Sara Migliorini, unfortunately, has left the panel due to limited time, because as you were well aware, it was already past midnight in Hong Kong, and also Mateusz Groszowski for his presentation. In order to finish up our first day of the event in due time and not to ask overwork for the technicians and the people that are following us, I will move immediately to the last short presentation that is dedicated to the hypotheticals. One clarification that I would like to do as regards the hypotheticals is the fact that, as said about before, we have a situation where the transnational training workshop organized by the within this type of projects are usually in-person trainings, and the approach usually used by, at least from my perspective, but also from the other, from the Consiglio dell'Ordine, is to have a very lively discussion on the cases and on the potential cases that can emerge from these cases. So the issue is that we would like to show you some cases that has been drafted through the analysis of the jurisprudence that has been gathered through the project, and try to solve these cases tomorrow in the session that will be presented by Galileo Sartor, in order to show you that our tools, so the tools that have been developed through the project, can be helpful for you in terms of indication of competence, so the jurisdiction, but also competent courts, regarding jurisdiction, but also applicable law. So we would like to address these cases. You will find the content of these cases through the dedicated web page that will be created tomorrow by Andrea Pontecorvo. So I'm sure that you will find them also online. So the two cases that we will address are quite simple in order to make sure that we have very clear elements from the cases. And in one case, we will address the situation of a Russian citizen domiciled in Italy. So we have a specific situation, which access a website that is called Alpha Ski. And the company is based in Germany and is specialized in the marketing of Normandy apples, which are highly appreciated by local consumers. So the website is in French. So one of the issues that were emerging also from the discussion before from Sara Migliorini's presentation is the fact that this is an element that could be very relevant in terms of understanding which is the target audience of the website. And however, due to this popularity, the website also offers home delivery service for all Europe. And so our Tizio, a Russian citizen, becoming aware of this website thanks to a friend living in Normandy, decided to buy 50 crates of apple for himself and his family. So a few days after the delivery, Tizio notes that the apples are altered by a virus that, in addition to having compromised the taste of apples, have the potential to cause serious health problems. So we have a situation where we have a contractual relationship between two partners, and we have the need to address, in case of a claim against Alpha Company, to identify which is the competent court and which legislation and private international law is applicable. So we would like to address these issues tomorrow in the discussion, making sure that our documentation, our tools may help you in identifying, or at least having some guidelines, useful guidelines, in order to identify the competent courts for the case. The other case that will be addressed tomorrow is the case regarding potential defamation case. So we have an Italian entrepreneur resident in Milan, which was unfairly accused of money laundering by a Greek competitor, which is resident in Belgium. So we have a criminal trial held in Milan, which ends with Rossi's acquittal in 2008. So a few years later, we still have an interview by the Greek competitor to a popular German online newspaper, and the accusations of money laundering are repeated. So the issue is that we have a second criminal trial where Mr. Farkis, so the Greek competitor, is convicted for defamation, and the German news is ordered to remove the interview from the website. At one point, after some time, in December 2019, we have a Spanish company, which was an important client of Mr. Rossi, decides to interrupt the contractual relationship because it becomes aware of the interview given by Mr. Farkis on the website. So we have, in our example, we have a second indirect effect of these interview still available on the online newspaper website. The Portuguese bank informs Mr. Rossi of his decision to close his accounts in the Lisbon branch. So the bank is also claims to have made this decision after reading the interview on the German online newspaper. So these are the relevant factual circumstances. And again, we would like to address the potential case presented by Mr. Rossi against the online publication, in order to verify if the impact, so the decision taken by the Spanish company and the Portuguese bank, can be also qualified as damages based on the fact that the information, so the interview, was still available on the online platform. In order to address this case, we will also address how this information, these circus, can be interpreted in order to identify the competent court, and again to identify the legislation applicable to the case. So we would like to make sure that these are, again, very general and not specific and detailed cases. So there are still cases that can be discussed in detail and can have more information. If you have a folder with a case folder, obviously we'll have more cases. Still, it will help us in order to see if and how these cases can be solved easily and quickly through our online tools. I can close here with the presentation. Luckily, we still are in time as regards the cases, the timeline of our day for the event. And I thank again our hosts, so Alessandro Graziani, Cristina Tamburro, and the Consiglio dell'Ordine di Roma, and also the continuous control and the continuous help of Andrea Pontecorvo for this day. And I look forward to meet you tomorrow again at 3 in the afternoon in order to continue our discussion and to move forward to the presentation of the deliverables of the project. If Alessandro wants to conclude and say the last few words, I leave you the floor.
Okay, everything is gone well. We are arriving at the end of today. I wish good evening to everybody, and for the rendezvous of 3 p.m. tomorrow, I hope everybody could hear and see another part of this project. And I recommend to other participants of the Consiglio dell'Ordine degli Avvocati di Roma, all the Roman lawyers, to be punctual tomorrow at the same time, 3 o'clock in the afternoon. Good evening, everybody.